Hi, my name is Isabela Jones, and prior to my presentation, I would like to take this moment to thank the MiraCosta Honors Program for allowing me the time to present today, as well as my esteemed Business 120 professor, Cheryl Waitson, for giving me the opportunity and also collaborating with me on this project. I'll be presenting on the Cannabis Conundrum, more specifically the consequences of conflicting state and federal laws in regarding to the legality of cannabis and the catch-22 situation that creates between the employer and... So here's my thesis statement. Basically, I'm going to be talking about the current laws pertaining to the legality of cannabis in the United States on both the state and federal level, and the catch-22 situation that they create between the relationship of employer and employee all over the U.S. Also, talking about how this has created a great inequality for the rights of workers for those who use cannabis for medical and recreational users in comparison to their non-using co-workers. With more and more states continuing to legalize cannabis both medically and recreationally, the issue of workers' rights will only continue to become more complex with contradicting federal legislation. Just to give some historical background on this, up until 1996, there really existed no major conflict between state and federal legislation in regards to cannabis because it was legal at both levels. That year, California became the first state to legalize the prescription of medical use of cannabis under the Proposition 215, which exempts patients who use cannabis recommended by a physician from criminal laws otherwise prohibiting the possession and cultivation of cannabis. In recent years, the conflicting federal laws and state laws have created a lack of rights for employees who use cannabis, and several cases have been ruled on to try to resolve the issue between employer and employee. And a solution has yet been implemented to create equality in the workplace for cannabis users. Here, I have a chart depicting the changing social attitudes on the public opinion of legalizing marijuana from the years 1969 up until 2019. Here is the illegal side and the legality side. Here we can see in 1969, 84% of U.S. citizens were in favor of keeping marijuana illegal, whereas 12% were in favor of changing its status to legal. In 1979, we see a slight increase in those proposing for legalizing marijuana with 30%, and those in favor of keeping it illegal at 66%. In 1989, we see a huge difference here. 81% were in favor of keeping it illegal, and only a slim margin of 16% wanted to legalize the drug. Here in 1999, we see a shift upward trend in the legal section. 31% chose that they believe that it should be legal, where 63% said that they would like to keep it illegal. In 2009, same situation, 60% illegal, 32% legal, and it wasn't until around the late 2010s that we saw the shift in the trend of changing from a more increase in the majority of positive attitudes toward legalization. Until now, in 2019, 67% were in support of legalizing marijuana and only 32% were in support of keeping the drug illegal. My next slide here is a chart depicting the changing state laws. As you can see on the West Coast, for the main part, there's a lot of legalization here as it is a more liberal area of the U.S. This includes California, Nevada, Washington, Oregon, New Mexico. Over here, a lot of the East Coast states have chose either for medical use, decriminalized, or medical and recreational use, and only a 6 states still have it fully legal in the U.S., and this continues to be changing as we progress towards even more states voting on legality, which we will see in the next slides. In the 2020 election, there are actually 5 states that in their ballots were voting on the legality of cannabis. This includes Arizona, Montana, Mississippi, South Dakota, and New Jersey. In all 5, the overwhelming majority voted to pass legislation making cannabis legal both medically and recreationally in all 5 of these states. Now, 38 states allow adult usage, and that is over 76% of the population. It is only sensible that federal policies match up with the majority and adjust their legislation to support the majority of states that have legalized cannabis for both medical and recreational use. Now to discuss the state and federal legislation issues that differ and contradict. So although state laws have changed, as we can see, as more and more states choose for marijuana to be legal, federal laws haven't changed very much. So to start, enacted in 1986, the Federal Drug-Free Workplace Program made it a condition for employment that all civilian employees at executive branch agencies are prohibited from using federally illegal substances on or off duty, which includes marijuana. The issue with this is that over 56% of federal workers are veterans, and veterans use cannabis for many different ailments, suffering from PTSD, chronic pains, and more. On the positive side, this upcoming December, we will be voting on the Fairness in Federal Drug Testing Under State Laws Act, the H.R. 1687. This is a bipartisan legislation that explicitly bar federal agencies from discriminating against workers solely because of their status as a cannabis consumer or due to testing positive on marijuana use in a workplace drug test. We'll be analyzing several court cases to show how conflicting federal and state laws have affected people in the workplace. The first case I'm going to be talking about is the 2017 case of Barbudo versus Advantage Sales that took place in Massachusetts. Just to give some background information on the case, Christina Barbudo suffered from Crohn's disease, and because of that, her physician recommended her a medical marijuana card in a state of Massachusetts that medical marijuana use is completely legal. Now that you know that, here, in the late summer of 2014, Christina was hired at Advantage Sales Marketing LLC, but was required to take and pass a pre-employment drug test. Prior to taking the drug test, Barbudo was sure to inform her soon-to-be employer of the condition that she suffers from, as well as the fact that she uses medical marijuana as a treatment. After a single day of employment, an ASM representative reached out to inform her that she had tested positive and that she was terminated from her employment. Christina took the position that ASM should not apply the drug test to her because of her Crohn's disease and that she is medically prescribed the drug. The Massachusetts Judicial Court, issued an unanimous ruling allowing medical marijuana users to assert claims for handicap discrimination under the Massachusetts Fair Employment Practices Act. But on the other side, the court also ruled that Massachusetts Act for the Humanitarian Medical Use of Marijuana does not imply on any private right of action by employees against employers. The court also declined to recognize a claim for wrongful termination and violation of public policy for medical marijuana users. But this is also because an alternative claim exists with the handicap discrimination. So although Christina Barbudo was able to get some sense of justice through the handicap discrimination because of her Crohn's disease, it still did not serve her justice because of the fact that medical marijuana for her was completely legal in the state of Massachusetts. And we can see how, because employers have had to follow federal legislation, it has contradicted with state legislation such as that of Massachusetts, creating issues that Christina Barbudo didn't really deserve to be fired in the first place. The second case that I'm going to be analyzing is the 2014 case of Braska vs. Challenge Manufacturing that comes from the state of Michigan. Just to give some background information about this, Rick Braska was a medical marijuana user due to chronic back pain who lives obviously in the state of Michigan. Keep in mind that in Michigan, cannabis use is legal both for medical and recreational reasons. Anyways, back to the story. So Braska began working for the Challenge Manufacturing Company in 2009, and in 2000, he was a material handler and a high-low operator. However, in 2010, he ended up actually injuring his ankle on the job. So he was taken to the medical center where after examination, he was required to take a mandatory drug test. After testing positive for said drug test, he revealed that he used medical marijuana for the chronic back pain that I stated earlier, and also revealed that he had obtained a physician-granted medical marijuana card in the state of Michigan. Shortly after, the company terminated Braska's employment for violation of the company's drug-free workplace policy. Braska then filed for unemployment following his termination, and the Unemployment Insurance Agency found that he was not fired for deliberate disregard of the employer's interests, so he was not disqualified to receive unemployment benefits. The company protested this determination, and the UIA determined that under any circumstance, he would be allowed to receive these benefits because he had a valid medical marijuana card, as well as a valid reason to be using medical marijuana in the first place. The court ruled that the denial of unemployment benefits constituted a penalty under the MMMA for the medical use of marijuana. The MMMA preempts the MESA, which is the Michigan Employment Security Act. It states that if an employee tests positive for controlled substance, then that person is disqualified for unemployment benefits. This ruling does not prevent an employer from terminating an employee for testing positive. The employee is not a state actor. Instead, it prevents governmental entity from penalizing a patient to their medical use of marijuana, which is protected under the Act. If the employers effectively challenged the medical use of marijuana, it would have been a different outcome. As you can see, the federal and state legislation laws that contradict each other have ended up in the firing of Rick Braska in this situation. Fortunately, he was able to receive these unemployment benefits because they come from the state and the state allowed this. But we can see how these contradicting, again, in another case, how the contradicting legislation has caused for a wrongful termination of yet another U.S. citizen. The last case I'll be covering is the 2018 case of Whitmire vs. Walmart stores hailing from Arizona. This is a really important case to analyze because, as we know, Walmart is a huge Fortune 500 company and it is also run multinationally, so the impact of this case is really great. So just to give a little background info, Carol Whitmire was a Walmart employee who had a medical marijuana card. Keep in mind that in Arizona it was legal on the medical level. And she was fired from the Fortune 500 company solely due to a positive test. Whitmire had been using cannabis since 2013 due to her chronic pain, smoking the drug before bed for pain relief and sleep aid. A few years later in 2016, she injured her wrist on the job. She made an incident report with Walmart the same day, but did not try to get any medical attention at the time being. Just 2 days later, she reported to Human Resources that the swelling and pain in her wrist was continued and she was directed to an urgent clinic. At the urgent clinic, she received a wrist examination and a post-accident urine drug test, in which she came back positive for cannabis. Walmart concluded that, upon reasonable belief, her positive test result for marijuana indicated that she was impaired by marijuana during her shift the same day. Now, if many of you don't know, someone who uses marijuana regularly, or even just casually, maybe once or twice a month, the drug on a urine test will show up to 30 to 60 days from the time of use. So for Walmart to say that she had to have used it during her time of employment while she was on the job that caused the accident is a completely unbacked statement, because she could have smoked it a month ago and it still would have tested positive. Anyways, the terminated employee filed suit against Walmart claiming she was wrongfully terminated and or discriminated against in violation of various state laws. A federal district court judge granted sua sponte, a summary judgment in part for the plaintiff, on the question of Walmart's liability for discrimination under the Arizona Medical Marijuana Act, or the AMMA. The judge states, without any evidence the plaintiff used or possessed or was impaired by marijuana at work, it is clear the defendant discriminated against the plaintiff in violation of the ARS 362813 of the AMMA by suspending and then terminating Carol Whitmire solely based on her positive drug screen, thus ruling in favor of the claims made by Carol Whitmire by the Fortune 500 company Walmart. As you can see here, although in the court case, Carol Whitmire got the better of the ruling and was proved that she was discriminated against by Walmart, it is still unfair that again we see someone wrongfully terminated solely due to marijuana use because of faulty legislation at the federal level. So that's 3 separate cases that we've seen how federal legislation has created not only a complex relationship between employer and employee, but also one that creates inequality for workers, for worker compensation, and injury compensation rights. The conflict between federal and state laws, as seen through those 3 past cases, has created a really large strain in the relationship between employer and employee. Even more so, businesses are weary. Since many do want to provide cannabis users with the same rights as their non-using co-workers, but the federal laws prevent them from doing so, even when it is legal at the state level. This has created great inequality in the workplace for cannabis users, especially concerning workers' compensation, injury compensation, and pre/post-screening drug tests. Now lays the question, can this be resolved? Since the overwhelming majority of states have already legalized or are in the process of making cannabis legal at the medical and recreational level, the change for equality needs to come at the federal level. So what does this mean? If you don't know, the way that we begin with policy implementation and changing legislation comes from Congress and the legislature. This starts with a vote in the House of Representatives that will later be passed on in the Senate, which I'll talk about in further slides since there's a really important vote coming up in December. With this year being an election year, along with that, whichever candidate wins will have a huge impact on the future of cannabis legislation in this country. Keep in mind that at the time of this video, we still don't know the outcome of the election, so I'm going to be going over both candidates and the way they have enacted on policy and the possible outcomes of whoever wins in regards to marijuana legislation. Of course, I will start with our current president, Republican Donald Trump. In the past, he has taken positions against easing laws prohibiting cannabis use. For example, in Trump's 2021 fiscal budget, he proposes to remove protections for state medical marijuana laws. And even further, he even took action to strip away the rights of cannabis users when his 2018 administration rescinded the 2013 Cole Memorandum Policy. The Cole Memorandum Policy was actually implemented by the Obama administration and prohibited federal agencies from going against people for prosecuting people for cannabis legality issues in states that cannabis was already legal. He actually resigned that. Now, Democratic candidate Joe Biden. Joe Biden states in his campaign site that no one should be in jail because of cannabis use, allowing us to conclude that he is much more supportive of implementing laws that support cannabis users. Furthermore, the Vice President also stated that he would like to decriminalize cannabis use and expunge criminals for prior convictions while leaving legality up to the states, saying that federal legislation wouldn't contradict that of the states. However, his Vice President Kamala Harris has recently been under fire for harshly punishing those charged with cannabis-related crimes during her time as District Attorney of California. So it's hard to say what Joe Biden would do when put in the position of president. I would also like to add some of my own recommendations for what I think would be the solution to ending the contradiction between state and federal legislation. My plan is about reconciliation to end discrimination. This starts by a bill that I talked about earlier that's going to be voted on in December to remove federal penalties on marijuana and also scrap some cannabis-related records that will receive a vote on the House floor in December. There's no guarantee this will get passed in the Senate, though, because of people like Mitch McConnell. Executive options, such as a new Attorney General appointment, reinstating the Justice Department memorandum, or moving cannabis to a Schedule II drug, are all options that could possibly move cannabis legislation on the federal level in the right direction in support of cannabis users. As you can see, moving cannabis to Schedule II, currently it is a Schedule I drug, meaning that we treat it the same way that we treat heroin. However, moving it to a Schedule II drug would allow the federal agencies to do more research on the drug, to possibly find more positive benefits, and give the U.S. a different outlook on the way that we see marijuana in our country. Just to summarize all of this, the current inequality that the cannabis community faces in the workplace can only be resolved by major legislation reform at the federal level, and that starts at the legislative branch. This year's election will be momentous in deciding the outcome of what said reform will look like in the near future. And one can only hope that this is just the beginning of a step in the right direction, providing equal rights and justice that will end discrimination against those who use cannabis in the workforce in comparison to their non-using co-workers. Here I provided my work cited, and I will also provide a link to the PDF form of my presentation so you can get a better look at this. Lastly, again, I would like to thank the MiraCosta Honors Program for giving me this opportunity to present, and again, I'd like to thank my wonderful professor, Cheryl Wadeson, for collaborating with me on this and helping me through this whole process. Thank you.